Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, so this is a Diddy update. Last we spoke, Diddy submitted a letter to the court asking them to grant him an extension to actually respond to the government's submission of their response regarding the MDC sweep, as well as the BOP investigator and why he took pictures of Diddy's things during the sweep. Let's hop right on into it. So this letter was submitted on Friday, and it reads that we write on behalf of Sean Combs to respond to the declarations submitted by the government on January 17, 2025, and in further support of Mr. Combs' motion for a hearing, suppression, and other relief. The declarations show that ever since the government first tried to use Mr. Combs' privilege notes to continue his detention, it has presented a materially false narrative about how it got access to the sensitive, privileged material contained in his defense strategy and communications with his attorneys. Most significantly, the declarations reveal SDNY supervisors directed the BOP to search Mr. Combs' unit because of its investigation and prosecution of Mr. Combs. And they demonstrate the government has consistently monitored Mr. Combs' legal calls. In other words, they confirm that what Mr. Combs had been arguing all along, that the search was conducted based upon a pretext, not for any legitimate penological reason, and that investigators surveillance before and during the search violated Mr. Combs' constitutional rights and invaded the attorney client privilege. First, the declarations refute the government's repeated claims that the BOP sweep was carried out solely to further legitimate uh, penological interests and did not target Mr. Combs. The declarations expose that after the sweep begun, it was unclear whether Mr. Combs' unit would be searched at all. Moreover, the search of that unit was carried out specifically at the direction of SDNY supervisor, including the supervisor for this case, because of the interest in obtaining evidence against Mr. Combs. Second, the declarations show that Investigator 1 became an agent of the prosecution team and worked to advance its case. He searched Mr. Combs' bunk for evidence, not contraband, and it is clear his purpose was to gather evidence for the prosecution, not police any potential threats to MDC security. Indeed, it is notable that even though he has been surveilling Mr. Combs' communications for months, to this day, the BOP has not taken any actions to discipline Mr. Combs for any purported violations of MDC policies. Mr. Combs has never received so much as a write up in his 4 months in BOP custody, despite the government's repeated complaints about his alleged obstruction from MDC and supposed violation of policy. Third, the declarations confirm that the government was complicit in Investigator One's continuous monitoring of Mr. Combs' privileged communications. Investigator One admits he listened to Mr. Combs' calls, including with his counsel, and that all those recordings, including the ones with his attorneys, are being furnished to the U.S. Attorney's Office. Finally, the declarations raise additional questions that cannot fully and accurately be answered except through discovery in an evidentiary hearing. As just one example, despite reporting to prosecutors that he personally took those photographs of Mr. Combs' notes, and then they redacted that, the declarations are inconsistent with each other, omit key details, rely extensively on hearsay, and are remarkably vague as to key points. The truth will only be fully revealed if the government's claim can be tested through cross examination of witnesses who have actual knowledge of the material facts. Likewise, the court cannot fashion appropriate remedies without the complete information that can only be discovered through such a hearing. I wish that we could see what in the world the BOP investigator did, why he did. Oh. All right, one, the government misrepresented the facts and tried to conceal the constitutional violations. All right, paragraph A, SDNY prosecutors, not the BOP directed the search. The declaration contradicts the government's prior representations concerning the reasons for the search and who directed it. The government previously claimed that the MDC sweep was planned by prison officials well in advance of Mr. Combs' arrest, was motivated solely by the legitimate penological interests, and did not target Mr. Combs. And further claimed no one on the case team supervised, conducted, or participated in the search, and that the search was organized and executed primarily by BOP staff. These claims were essential to the government's opposition, which rested on the notion that prison officials are presumed to do their best to evaluate and monitor objectively the security needs of the institution, including in deciding whether a search is necessary. But these claims were false. The truth is that the search of Mr. Combs' unit apparently was not even part of the BOP's original plan for the sweep, but it was SDNY supervisor, including the trial team's own unit chief, Supervisor 1, who ultimately directed the search. And the search was conducted not for legitimate institutional security reasons, but because Supervisor 1 was interested in searching Mr. Combs. I don't think so. That's not what I got from that supervisor's letter or her declaration. Definitely go back and watch the last update that I did so you can understand what the supervisor one stated in her declaration. It reads specifically on the morning of the second day of the sweep, representatives from the BOP and other federal agencies met to discuss a potential search of Mr. Combs' unit. The agencies had not previously decided whether such a search was necessary and inquired into the position of the USAO SDNY regarding the potential search. Supervisor 2, an SDNY unit chief who helped plan the MDC sweep and was present during the sweep, then discussed with Supervisor 1 whether Mr. Combs' unit should be searched. Supervisor 1 stated that it should be searched in part because of what the prosecution team had learned regarding Mr. Combs's conduct at the MDC. Supervisor 1 conferred with SDNY senior leadership and relied to Supervisor 2 that Mr. Combs' unit should indeed be searched, which Supervisor 2 further relayed to BOP, leading to the search. Thus, while AUSA Slavic claims no SDNY personnel directed how the search of Mr. Combs' unit would be conducted, she can't deny that SDNY supervisors directed the search itself. That flatly contradicts the government's prior representations. Paragraph B states Investigator 1 was searching for evidence and not contraband. The declaration also contradicts the government's prior narrative concerning its relationship with Investigator 1 and his motivations. The government previously claimed that the case team's investigation and the BOP investigation have operated independently, and that Investigator 1 was merely searching for contraband, not evidence, during the sweep. The declarations show that both of these claims were false. In fact, the government and Investigator 1 worked in a coordinated fashion for at least 2 weeks leading, oh man, up to the MDC search. And the trial team encouraged Investigator 1 to monitor Mr. Combs' communication. BOP personnel contacted Supervisor 1 on October 10th, 2024, to inform her that Investigator 1 was monitoring Mr. Combs' communication and found relevant evidence. The date is significant because it was 10 days after Mr. Combs filed his widely publicized notice of appeal concerning the detention order, and the same day the court invited the defense to make a renewed bail application. Notably, the SDNY supervisors on this case have been present for all court appearances in the matter, including that October 10th conference. He spoke with AUSA Slavic on several other occasions on October and November 2024. Although AUSA Slavic never specifies when or in what capacity these conversations took place or what was discussed. Investigator 1 clearly became an agent of the prosecution team. He collected, screened, and shared evidence while collaborating with a trial team prosecutor, and the fruits of his investigation were ultimately used by the government to try to detain Mr. Combs. He made a point of alerting them to Mr. Combs' plans to discredit possible witnesses and find dirt on people. In other words, core defense strategies protected by the Sixth Amendment, unrelated to the legitimate penological concerns. And the prosecutors have used the information Investigator 1 illegally obtained in various ways. We cannot know the full extent of the improper uses of the fruits of each of the search without a Castigar hearing, but for example, redactions, da 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 da. And despite the government's claims that Investigator 1 was monitoring Mr. Combs because of purported violations of BOP policy, Mr. Combs has not once been disciplined or even asked by the MDC to stop engaging in decided conduct. If Investigator 1's surveillance was generally undertaken solely for penological purposes, why does it seem that the fruits of his work have only been used by the prosecutors and not the BOP itself? Clearly, Investigator 1 searched Mr. Combs' notes during the sweep to find evidence for the prosecutors. He was not searching for purported contraband as the government previously represented to the court. Moreover, AUSA Slavic states that the BOP was looking for narcotics, weapons, and electronic devices, none of which could possibly be found in the pages of Mr. Combs' notes. The contraband excuse was thus clearly a pretext for the unlawful search. I swear, the more I read, the more this is not looking good at all. The government did not proceed it in good faith and took no steps to avoid violating Mr. Combs' rights. The declarations confirmed that the government has, via Investigator 1, consistently monitored Mr. Combs' privileged communications with his attorneys. It is opposition to the defense motion. The government claimed it made good faith efforts to avoid coming in contact with privileged material, and that it is contrary to facts and logic to suggest Investigator 1 was its informant in the defense camp. But it turns out Investigator 1 has been spying on defense team all along. Investigator 1 thus repeatedly informs the trial team he was eavesdropping on privileged communications, but the trial team never instructed him to stop. That is outrageous. Worse, the trial team endorsed his conduct by requesting the communications at issue. Accordingly, the government has obtained and produced to defense over 30 of defense owned calls with Mr. Combs. That is egregious breach of Mr. Combs' rights, and the court should immediately order the government and BOP to cease any such spying on the defense camp. I'm gonna finish reading and then I'm gonna give my thoughts. The declarations show that further discovery and a hearing are required. The Slavic Declaration is permeated with unverified hearsay and lacks crucial details. The Slavic Declaration is largely based on unsworn hearsay, much of which is vague and raises more questions than its answers. For example, the discussion between the unidentified BOP personnel and Supervisor 1 on October 10, 2024 lacks any detail. Important question remains: who are the BOP personnel? What was said? Why was Supervisor 1 contacted seemingly out of the blue by BOP? And how did the BOP know who to contact? Based on the chain of events, it is likely that BOP had standing orders from Supervisor 1 or SDNY personnel to monitor Mr. Combs and report on his conduct. When were such orders given and why? And where there other communications leading up to the call? I think they meant to say were. um, AUSA Slavic also fails to share what she personally discussed and when with Investigator 1. She merely states, I spoke with Investigator 1 on several other occasions in October and November 2024. But again, glaring questions remain as to what was said and what expectations arose from these communications. The declaration further references, without describing, multiple conversations and meetings, including BOP personnel, certain SDNY personnel, and other government officials. It references multiple other conversations and meetings between Supervisor 2 and 1, during which the supervisors specifically discussed Mr. Combs. There are also reference to conversations between Supervisor 1 and SDNY senior leadership. The court's consideration of Mr. Combs' motion should not be based on such rank, nondescript hearsay. Further discovery and testimony from these individuals are required. Okay, this is they're talking about the filter team. Okay, so this is in regards to them talking about that the government should immediately and the BOP cease on spying the defense camp. So let's look at this footnote because it's interesting. The government claims it directed Investigator 1 to produce the recordings to the filter team, but that is cold comfort for this egregious breach of Mr. Combs' Sixth Amendment rights. As we explained in prior submissions, the filter team process has failed as a production of multiple privilege notes to the case team, which the court had to order clawed back, uh, amply demonstrates. In addition, since the filing of this motion, we have discovered multiple additional instances of privileged material being produced by the filter team to the case team. For example, after defense counsel alerted the case team to the existence of a potentially privileged notebook from Mr. Combs' Miami residence that was searched in March 2024, the notebook was produced from the filter team to the case team without any input from counsel. It was not until this instant motion that the defense was given the opportunity to make privileged determinations regarding the notebook. Additionally, multiple communications from an attorney at the law firm that has been on counsel's privilege list since April has had been in the case team's possession until defense asked for them to be clawed back. The defense has initiated other clawback requests in connection with additional privileged materials the filter team passed to the case team. And I was going to save my comments to the end, but they already said my thing is with the filter team, because if the filter, that's the whole purpose of having the filter team. So when, and I get it, um in no way, shape, form, or fashion should the BOP investigator should have taken any privileged material from that cell. If his job was to check the cells for narcotics, contraband, and things in that nature, because that was what the MDC was about. Okay, that should have been it. There was no reason for him to even, or her, I don't know if the BOP investigator is a he or her, but there should have not been any pictures or anything taken from his cell, because what you're doing is you're damaging the case. He does need a fair trial. Diddy is entitled to a fair trial, and by people doing illegal stuff, you jeopardize that right. Anywho's, even though it was done, right, it went through the filter team. And the filter team determines what should go to the prosecution or the defense counsel. Oh, man. Um, as just one more example, the Slavic Declaration states Investigator 1 provided a high level overview of the contents of the BOP notes, including the defendant's plans to discredit possible witnesses and find dirt on people. What specifically did Investigator 1 say? What witnesses were identified? And what else was communicated regarding the notes? Perhaps directing Investigator 1 to provide the photographs to the filter team in the first instance provided some cover for the case team, but if the high level overview revealed the substance of the notes, it was not a legitimate way to ensure that the case team was not tainted by access of privileged information about Mr. Combs' defense. I promise y'all, I'm on the fence about this because depending on the severity, like if Diddy does had a plan to discredit witnesses, oh my gosh, I can't believe I'm saying this. Then it is a good thing because at least we know that that is his thought process, his goal to get rid not get rid of witnesses, but like are you blackmailing them? Like what do you have on this is a whole new can of worms. All right, so investigator B, I'm sorry, 1. His declaration lacks important detail. Curiously, in contrast to the Slavic declaration, investigator one's declaration nowhere states that he described the contents of Mr. Combs' notes to a USA Slavic. Why the inconsistency and what is he hiding? Inconsistencies like this undermine the credibility of the declaration and further underscore the need for a hearing. Indeed, it is clear Investigator 1 previously misled prosecutors by telling them he took the photographs of Mr. Combs' notes. That is apparently not true. Yet, Investigator 1's declaration still fails to identify the individual who actually took the photographs. What? So it wasn't him? Who is this person? What did he do with the photographs? Who else saw them? And did the government have any communications with that individual? Did the government ever interview that individual before filing its response to Mr. Combs' motion or to comply with the court's order to file the declaration? Now, this is crazy. So, investigator 1 did not he's not the one who was in the cell. It was somebody else. Uh ay ay ay. The prosecution team also includes supervisor 1, 2 and the SDNY senior leadership. So the government uses a severely limited definition of prosecution team in attempt to withhold critical information and dodge accountability. But as explained in Mr. Combs' motion, the right at issue prescribe unlawful searches by government actors, generally including any BOP or USAO employees, not just searches carried out by the case team. In any case, the prosecution team, as defined by the Second Circuit, plainly include the SDNY supervisors and senior leadership. It includes, for example, the prosecutor's office generally. Let me see. Supervisor 1 and 2, as well as SDNY senior leadership, are not far flung members of the executive branch. These individuals regularly observe the proceedings in this case and supervise and sign off on trial teams' investigative activities and trial strategy. The court should order discovery and declarations from these individuals and eventually take their testimony at a hearing. Lastly, the government should produce the emails and other evidence. The government mentions email communications, and the MDC is wired with surveillance cameras that recorded the relevant search. Ooh. The court should order the production of this evidence and any other evidence in the government's possession relevant to the motion. It is most reliable means of testing the government's dubious claims. Instead of sharing the full story, the government has cherry picked a few facts and submitted declarations that undermine the credibility of its previous submissions, omit key facts, and raise numerous important questions about what really happened. A full hearing in which Mr. Combs' counsel are afforded the opportunity to cross examine the government actors with knowledge of facts relevant to the search is the only way to find the true facts and understand the full picture so the court can access how best to remedy his grave violation of Mr. Combs' constitutional rights. Mr. Combs therefore Mr. Combs therefore respectfully requests that the court order the government to produce the additional discovery described in this letter as well as whatever communication it has already shared with the court in camera and hold a hearing. Alexandra Shapiro and Jason. Oh, these are the new people that came into play. Mm-mm-mm-mm-mm. Um, I do agree that his constitutional rights may have been violated because it does not make sense as to why that investigator or whoever is up, because now it's saying that the investigator wasn't the one who even searched the cell, it was somebody else. So now I know the judge is going to be tired at this point. I do see that there is either going to be a hearing so they can discuss further, or the judge is possibly going to um, ask that the individual who actually swept the cell of Sean Combs submit their declarations, because now it's not making sense as to why, like who authorized that, why did they feel the need to uh, take items out of the cell, take photos of privileged material, even though it may not have said attorney privilege. It is the fact that they still went in there and did the complete opposite of what was supposed to be done. It was an MDC sweep. This is something that was planned prior, a couple of months prior to Sean Combs even being arrested. The goal was to search for narcotics, and other things related to that, not to go into his cell and take photos of material that had nothing to do with the MDC sweep. This is something that will have to be addressed, something that I'm pretty sure all of us wants to know because it is out there. But what are you guys hiring? What are you hiding? Now, do I think that because this happened, they're going to allow Diddy to get out of jail? I don't think so. And the reason why I'm saying this, even though that these things was obtained, I guess I'm gonna use the word illegally. What has been revealed is that Diddy is, making he's trying to discredit witnesses. He's contacting them. He's saying things. Um, just him being out is not good for anybody, and that is for protection of the witnesses and the victims in this case. So I don't see the judge granting him, bail to get out, because that is still something that is feared. But as far as the government doing what they're doing, it's not excusable and it's not right. But y'all let me know what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and have a good one. Bye.